One network.
General public is the key.
You know, the people who are using wireless, they may not be protected, but the people who are on the wire are.
Don't get us wrong. The wireless question is so shrouded in grayness.
And I'm not saying I endorse a particular view of it. Again, as a privacy person, I'd say I want the interception laws to fully apply to that jackass in the cafe who's trying to snip my password.
If at any point the court decides that there is an expectation or no expectation of privacy for wireless, then his question becomes fully relevant that the senator didn't expect his wireless communication to have any privacy, but all of a sudden I'm on the wire sniffing it.
Yeah, although, believe it or not, that's actually the law for electronic communications has nothing to do with reasonable expectation of privacy. That's a Fourth Amendment.
I know. I'm saying that if the court at any point ever says, hey, there is no expectation of privacy there, but there is on the wire.
I always like to say it turns on the facts. If someone's sniffing in a really malicious way wireless packets, if I were the prosecutor, I'd say, yeah, let's test this. Let's go after them. Let's indict them. Let's put them through the hell of being searched. I don't care if it was wireless. Let's throw it at them.
Moral of the story, don't be the first person caught doing this.
Yeah.
In terms of the protection of your networking things, would the protection of your company's reputation be something worth protecting?
Yeah, again, same question. Is that rights and property?
Is that a property interest? Do you have a legal right to your reputation?
Maybe.
I would suggest you rely on that.
Concept of slander, so clearly reputation is important.
You probably have a better argument than with porn. Well, with porn there are also arguments about liability and things like that.
But if your organization is explicitly anti-porn, then disseminating porn from your network would be contrary to your corporate interest.
Yeah. So the question is rights and property. What does that mean? No one knows. Yeah.
Well, and again, I mean, in the context that it's been analyzed, which is the phone context, it's been narrowly limited to fraud prevention.
Would the argument have changed much? I know this was a complicated trial. If you pursued the idea that one of the photographs actually portrayed a crime in progress?
Technically, it did. That's a crime.
Well, there would have been an exception for the disclosure, probably. That would not have excused the initial interception.
Sex with sheep is a crime.
The after-the-fact content that you find after an interception's been done can't justify.
I don't see why. Yeah.
Okay, I got a question in the middle here.
Yeah, I think that one point in this case, how do we interpret the existing law in this digital life case? So let's think about the real life case. What if you invite people to your home, and they, without your consensus, they get interested and get too intimate? Do you have the right to take photographs? If you did,
That's an interesting hypo.
And there's also another question, like if you use flash and disturb these two guys.
Senator, was that?
Stay away from that one.
Yeah, I mean, the reason I don't know if that's exactly analogous is because we have a law here. We have a written statute that says what you can and cannot do. You're talking about all the vague world of common law tort, probably, or maybe even criminal law, and it's not going to be as clear. And so I don't think the outcome there necessarily dictates the outcome here. Right? The whole problem with internet law is choosing the right analogy, and it's always a tough one. And I have to say, actually, after we've answered 10 questions, if I could pull way back from it, because I know there is one person in the room at least who still works for the Department of Justice, I think DOJ would say rights and property is broad. Rights and property means Congress wanted you to be able to protect your networks. Congress gave you free rein. They put vague language in there because they want it to be broad. They want it to include porn. They want it to include fraud. EFF is going to say the opposite.
And they said in their legislative history it was meant to preserve a common law defense for protection against fraud.
Granted, I'm just saying I feel obligated. There's this little DOJ bone in me that feels obligated to make it clear that DOJ probably would disagree a little bit with the advice, and they'd say it's a broad defense.
And he's probably right. I wanted to add an important point, though. In addition to interception, the acquisition of content, there are also laws governing the acquisition of non-content routing, signaling, and addressing information. So like header information. That previously only applied to dialed phone numbers, but it was updated in 2001 for the Patriot Act to include internet, because it's very easy for the government to get an order authorizing them to do that kind of surveillance as compared to a warrant. The problem is they expanded that to the internet without clarifying what that meant in terms of the civil liability for people who do it. And so right now there is a law that says you can't acquire header information unless you fit a very similar provider exception to the one we're discussing here. So all of the cautions we're giving you about acquisition of content would apply in terms of header information as well. If you're looking at it at all, if you're sniffing it at all, have a damn good reason.
Okay, I've got that gentleman back. You're next.
So I had a question about, in terms of the consent, how specific that has to be. So I made consent to have my communications monitored, but does it have to specify, particularly in an organization, that they're going to, what they're going to monitor for? And if those circumstances change, do they have to come back to each one of those individuals? For example, today, or 3 years ago, there was no phishing, now we're going to look for phishing, so I have to go back and get consent again.
Yeah, I mean, again, the court will ask a very simple question: what did you consent to? And if
but is consent accepted?
No, and so consent comes in all sorts of different flavors. And so one rule of thumb I think I learned from Richard Salgado is the longer your banner, the more likely it's a bad banner, because you've likely filled it full of reasons that you'll monitor and adjectives and times a day and all sorts of other crap, when what we really want to see as the Department of Justice is one sentence that says you are being monitored for any reason, and we can use it for any purpose. Now, that's not going to fly in a university. That's not going to fly with AT&T, but that's what they want. The longer it is, the more
that's pretty much what AT&T's policy is at this point. I mean, really, you should all take a look at all of your policies, and you'll be amazed at how many of them basically say, we can and will monitor if we think it's appropriate,
for any reason,
without really anything more than that.
But to answer your question, yeah, caveats will be read. Everything will be read, so don't have them.
There's also, I was just going to say, there's also some great, if you're looking for language, there's some great sample banners on the DOJ website at cybercrime.gov.
So one thing you were saying during the defense's closing argument grabbed my attention, which was, we have 3 options that they might have done. The third one was not provide access to the internet.
Right.
And I found it really interesting that you said provide access to the internet as opposed to provide access to the organization's network.
Right.
Because it implies that the organization wasn't providing access to their private network, to their own resources.
They weren't, probably.
Providing access to the internet globally, and therefore they weren't. And therefore, I mean, I guess you guys have probably intended to raise the question of net neutrality and what right to providers have to filter the internet.
I don't think we wanted to open that can of worms.
I saw it in the initial opening, and I kind of thought that's where you wanted to go.
Yeah, I thought where you were going with that is if they're just going out on the internet, what do you care? Why is it your right and property? And we intentionally did it that way because it stacked the deck a little bit more evenly. But I don't think we were going the other way.
The only net neutrality hook was the making fun of Stevens for the pipes thing.
Yeah,
that was about it.
Okay, you mentioned private property, and I believe there's some debate now about your property, your home is definitely your property, and you've got your protection there. When you take your laptop out of the house, at that point it ceases to be private property.
I don't think that's right.
The laptop is private property, but beyond that.
Yeah, it depends on what you mean by that. Well, again, these are all open questions. You really have to put it in context. Are you talking about in terms of can the police search it? Are you talking about can someone grab it from you and not be considered a thief? But even with all these questions, you walk outside with your laptop, that's still your private property. If you leave it in the park for 2 weeks, yeah, it might change. So.
This gentleman over here.
If you want to protect your own network, you can have use policy that says our companies are not allowed to serve porn because it degrades the network. That is, we don't want everybody downloading massive amounts of features because other cycles and it's going to be expensive for us.
Yeah, certainly we could have, and in a case like this, we probably would have tried to make an argument like that. In a jury of 12 techies, I don't know if that's going to pass the straight face test. Maybe it will. I don't know.
It's going to be a jury of 12 grandmothers, most likely.
But who knows? Yeah. Yeah, so there you go.
John? I just had a quick comment.
Just speak up.
The employee's time spent watching porn instead of doing what you're supposed to do. You protect your rights and property in that sense.
Yeah, okay, so again, right, these are all other arguments in addition to the liability argument, which personally I think has the most appeal. That's the one I'd most want to be making. But these are certainly like, it's almost like secondary effects. There's lots of bad secondary effects if we let any big files across, and porn seems to be the one our people really like. So we're trying to stamp out that. Yeah, certainly.
One comment over here, and then I'll take.
Yeah, I just wanted to comment because I had to write policies for a company recently, and one of the criteria for web surfing that they put in there I thought was a bit unusual. They didn't want their employees to be surfing sites that were on the State Department's watch list, which I thought was rather interesting because they didn't want their network showing up on a State Department watch list. So they had a whole list of different types of sites that many were, you know, sort of terrorist sites or things like that. So just thought that was kind of interesting.
Quick question. If my employee travels internationally, does my consent that I got from him still apply and connect back to my network? And
Sure.
I know you guys are international lawyers, but how does the rule of consent apply in other countries? Are they all sort of generally like the U.S., or are they all totally different?
I mean, to answer your first question, yeah, I mean, if they're your employee, they're coming in through a VPN or something, they're still on your network. You could still do your monitoring. Honestly, to call out on someone, Richard.
If you're a citizen of another country, but they work for you.
Richard, I don't know if you want to talk, but Richard may have a lot more to say about what other countries have to say about consent. This is Richard Downing, who asked those probing questions a second ago. I don't mind if you.
It's all over the map, I think, is probably the answer. A lot of countries don't even have rules on it, so it's really hard to tell. At least I have more exposure to Asian countries, and they're often uncertain.
Is that?
Maybe the European countries have much stronger data protection rules.
Is that part of the treaty?
European countries have, in general,
Hell no.
Is that part of the cybercrime treaty? Are they trying to harmonize consent rules, or I don't know the treaty well enough.
In certain countries in Europe, your actual rights, you can't forbid an employee doing certain things. So in the Netherlands region, you actually have a right that you can't tell them what website to get. If you're a French citizen and you sign away, you can't sign away your rights to do certain things. And if you haven't got consent, then as part of the employment rules, it actually travels with you to whichever country you travel.
The international angle reminded me of the intranational angle, which is, although with federal law, the consent of any single party to the communication is sufficient, there are a good number of states that require all party consent before you can intercept. Meaning that, say, if you had consent from your employee to intercept all their communications, that wouldn't help.
So this
Actually,
is what,
wasn't there a case in California?
well, this is
where
what tripped up. This, no pun intended. This is what happened to Linda Tripp. That she was in Maryland, I believe, when she was
Right.
taping Monica Lewinsky, and that's an all-party consent state. And so the fact that she knew that she had the tape recorder on her wasn't good enough. She actually had to get Lewinsky.
Well, wasn't there a case just in the California Supreme Court just ruled on about a company in Atlanta that intercepted somebody recorded from California, and they have both sides have to consent.
Rick, you're
and
nodding
ruled
your
that
head.
they illegally
You know this case?
Yeah, it was
recorded.
just the extension of the California Wiretap Act to say that it applied to an intercept that happened elsewhere, although one of the parties was in California. So it was typical, a state deciding that its laws actually extend, all the way around the world and back to the state again,
We have to thank California for that.
Which there's a lot of states do
Which
that.
working from Yahoo, you may not